Good morning, Madam Deputy Registrar. Would you please call the matter? Thank you.
Good morning, President. Caribbean Court of Justice, Appellate Jurisdiction, on appeal from the Court of Appeal of Belize, monitoring hearing in BZCV number 2 of 2014 between the Maya Leaders Alliance and 24 other villages and the Attorney General of Belize. The members of this morning's panel are Mr. Justice Anderson, President and Presiding Judge.
Good morning, everyone.
Madam Justice Rajnos Lee.
Good morning, everyone.
And Madam Justice Ononiwu.
Good morning, everyone.
May we have the appearances, please? Thank you.
Good morning, Your Honours. Good morning, Ms. Thomas Roberts. I, Nigel Hughes, appear in association with Ms. Leslie Mendez and Mr. Alistair Jenkins for the appellants, the Mayan people.
Morning, may it please you, Lords, Your Honours. I appear together with Miss Samantha Matut for the respondent.
Thank you very much, Counsel. Are there any other appearances? If not, I should indicate that the authority, Professor Celorio, has indicated that she is regrettably unable to join us this morning. And in the absence of any other appearances, I want to welcome you all to this monitoring hearing, which in all probability will be the last such hearing conducted by the court. We are grateful to Counsel and your support teams for making the sacrifice to appear during the summer break and before the court term has properly begun. We were pleasantly surprised by recent communication from the respondent in this matter, which conveyed to us the impression that significant progress had been made in identifying a draft person to draft the legislation of an omnibus nature, which would cover the main issues in dispute between the parties. These would, of course, include the issue of the free prior informed consent consultation issue, where, of course, significant progress has already been made. The issue of delimitation of Mayan villages, and the issue of the nature of the customary land rights that would inhere in such villages. There are other very interesting provisions as well in the working draft, but as I said, the panel was interested very much to receive this fairly recent communication, and we're looking forward to perhaps a more in-depth update from the respondent. In fact, I think if you will allow Mr. Hughes and the appellants, we could perhaps start with the respondent to give us an update on where we are and where the respondent foresees that we will be going forward, and then we could ask the reaction of the appellants to this. So if that is acceptable, I would ask please Mr. Marshallek to give us an update on where we are and as far as you can tell it, the way forward. Thank you.
Yes, Your Honor. We do feel from our end that we've made some significant advances over the last few weeks. You will recall that at the last compliance hearing, there wasn't much to report because the minister had undertaken a review and had not yet made his determinations as to his recommendations for changes to the policy or the draft as it then existed. What happened since then is that we were able to meet, and the decision makers were able to meet, And a decision was taken that instead of running an independent review alongside the court process, that we would incorporate that review into the process. And the way we did that was we have appointed Minister Zabane and Minister Martinez as the government representative on the review panel, so that whatever review they conduct will be a part of the review panel's remit. And simultaneously with that, we agreed to settle the policy in the terms that it then existed and the draft, and pass those along to the draftsperson for finalization of a preliminary draft or review by the review panel. So I want to make the point that the draft is a starting point. It's not the end point. It's to keep the decision of the discussions focused and to give an indication of what the government thinks is an appropriate way forward. But it's subject to review by the panel, and there are no restrictions on the extent, the scope of that review. So where we are is that we identified a draftsperson who indicated a willingness to do the work within the 20-25 days that we had in order to bring us to the third week of October. And we're finalizing the terms of the engagement. She has made some adjustments to the letter that we sent. We've made those adjustments, and hopefully we can get that signed and the deposit paid today and the work started without any further delay. Once that draft is had from the draftsperson, it goes to the review panel, and the review panel can start their work in earnest. I understand that Professor Anaya and Moira Gracie are the representatives on the review panel for the appellants, and the government's representatives will be Minister Zabane and Minister Martinez, both of who happen to hold PhDs in their own fields, Your Honor, so that we have a review panel comprising 4 PhD holders, and hopefully we get a magnificent review and result from that process.
Thank you very much indeed, Mr.
Yes.
Marshalik. Before I go to the appellants, my colleagues, is there any questions you wish to raise with Mr. Marshalik at this time?
Not at this time, President. Thank you.
President, I just wanted to seek a clarification from Mr. Marshalik. Mr. Marshalik, you said that the policy and draft would be settled and passed along to the draftsperson, if I heard you correctly. Could you just clarify what you're referring to there? Are you referring to could you just clarify what 2 documents you're referring to in that regard? Thank you.
We also copied the 2 documents together with the instructions to the other side, as we had indicated we would. There is a Mayaland policy document which sets out guiding principles and overriding objectives of the proposed legislation. And we also sent a working draft of the proposed legislation as a way of indicating in more detail what it is we contemplated. That now goes to the draftsperson for fine-tuning, revision, confirmation of a draft bill, the formulation of a draft bill. And then that draft bill goes to the review panel for work in earnest. And we thought that would have been the quickest way to get us to a result.
Mr. Marshall, thank you for that. So it means, therefore, that those are the 2 documents attached to the engagement letter.
Yes.
That you copied, you filed with the court. One very small matter I forgot to raise before. I take it, therefore, that the draftsperson has agreed and accepted the brief and has signed off on it.
She made some changes to the terms, and I've accepted the changes, signed it again, and sent it to her. I expect that it will be signed today. And once that's signed, it's a matter of getting to her the deposit, and the work starts. So we're hoping that can be done by tomorrow.
Thanks, Mr. Marshall.
Yes.
There Was Mr. Marsh, like at some point, the proposal that the public would be involved in some kind of consultative capacity, is that still a window of intervention that you are entertaining?
Yes, that comes after the review panel's work is
Right.
done. And the bill, whatever form it takes at that time, is again presented and revised, or whatever needs to be done by the draftsperson. And then that is the bill that then goes forward to cabinet and goes through the normal public consultations as any other bill would. So not at this, the answer is not at this early stage, because the draft are really suggestions and they do need some work.
Yes.
But it's to focus that work and show what it is and where it is, to have something to work with, really,
Yes, of
rather than
course.
working from thin air.
And just to pin down the timetable once more, you're hopeful of having that draft. Is it late October? I've forgotten the date of the judgment, but by the judgment's anniversary, I think.
I think you will have a draft presented to the review panel
Yes,
by that date. But then the review panel starts its
we'll
work.
take something.
And
Okay.
we have not limited the scope of that review in any way. So I'm not sure how long they will take. Initially, we had allotted 30 days. I expect they might want longer. In one of the roadmaps, it's not, I don't know how long the review will take.
Thank you. Okay. Nothing further from my colleagues, I see. So, Mr. Hughes, the appellants wish to provide an update from their perspective.
We do, Your Honor, and with your permission, may I defer to Ms. Mendez?
Thank you. Ms. Mendez?
Yes, Your Honors, may it please you. We have received a copy of the working draft and the instructions to the draftsperson. We received that earlier this month, Your Honors. I don't think that we share in the same optimistic spirit that I think that the court has welcomed it. And we are a bit disheartened to hear that this might be the last monitoring hearing. So if I might persuade the court to reconsider that. The reason for that, Your Honors, is that throughout these past 2 years, I believe, we have been reiterating the same core concerns when it comes to specific aspects of the policy that we now see somewhat hardened in the working draft, at least from our perspective. Now, in these proceedings, Your Honors, I don't think that we can continue knocking on what appears to be, in our view, a closed door. But our hope is that the review panel will, in fact, result in some positive outcome and that it will inform further drafts. And in our humble estimation, Your Honors, I think that the role of the court would remain critical, even at that point, for us to be able to continue participating in the process after the very first draft of the bill, Your Honors. We are eager to hear. I know that my learned senior has said that the scope of the review panel has not been in any way limited, but I think we still have to articulate it somehow. So we're eager to hear as to what that would be and a sort of timeline for the review panel, and what really is the anticipated treatment of that report that will be produced by the panel, by the government. I think that those are key questions for us to maximize really what the role of the review panel will be. As my learned senior has indicated, we have already shared our representatives with them. They are definitely eager to start. But those are our immediate reactions, Your Honors, to what has been shared before the court now.
Thank you. May I ask whether you were consulted on the selection of the draftsperson?
No, Your Honors.
Okay.
I had sent a couple of requests over the last year. And we had also sent some suggestions, if the court might recall. We had also sent a couple suggestions. But ultimately, the last thing that we have heard, it was just getting the letter where the draft person was already being received.
Yes, yes. I hear you. Of course, there's also an issue of urgency, and we have all been guilty of trying to push the process as far as we could. So that also has to be taken into account.
Yes, Your Honors. No, yes, Your Honors. Just to emphasize that it's we're not necessarily pushing back on the legal drafts person, but it's the first time that we've gotten the working draft. And when we're looking at the working draft, in fact, some of our concerns now have become larger because the core concerns that we have hardened and expanded with now this new draft that seeks to unpack a little bit more what the policy is. So that's at the core of the concern right now, not necessarily who they have selected as a legal drafts person.
Yes.
Yes, Your Honor, if I may.
Yes.
I believe some of the candidates for drafts person have been put on a review panel. So I thought that review would take place in that context rather than formalizing the draft as a starting point, the working document as a starting point. It's to really kickstart that process.
Yes, and I presume that you're comforted to some extent, Ms. Mendez, by what was said earlier about the remit of the review committee, that there are no limits. And of course, representatives of the appellants are free to make whatever suggestions they wish to the draft bill when it comes before them. At the end of the day, of course, the responsibility is that of the government to ensure the carrying out of the consent order. And we would like, of course, to avoid a situation where that consent order is implemented in a way which is not to the satisfaction of the appellants, to the extent that the appellants feel completely unable to accept it. We're hopeful that the process of going through the review committee will help to lessen the distance, differences between the two sides. With the assurance that there are no restrictions on the scope of the review committee, the fact that you have equal representation on it, I'm hopeful that that represents a process which will allow us to arrive at a mutually agreeable solution. I must say that from our point of view, we are a little bit hesitant to go beyond this point because we are concerned about blurring the lines between monitoring and adjudication. I think we've arrived at a point now where both sides are in a process which is designed to arrive at the final product. And from here on, I think the views which are going to be put, if they can't be solved by consensus, will likely be views which will appear in another format. And therefore, we are very wary. I will consult my colleagues, short break, but we're very wary of going beyond this point for that reason.
Perhaps just one more, Your Honor. That lands us at the anniversary and the presentation of the first draft, and we could just update, and that could be the final update, Your Honors. It's just that we haven't really gotten the first draft. And so I think that a final one would be useful to send us into that stage now builds consensus with the report, with the review panel.
And that will be likely before the end of October.
Yes, Your Honor. You see, I appreciate what Your Honor has expressed with respect to the review panel. And there is some advantages about the wide scope that has been articulated by my learned senior. But I do think that there still needs some guidance. It can't be a process that is completely unmoored on any principles or any direction as to how this report ought to be treated. So those are my concerns. And that's something that perhaps it would be useful to update the court at the next and last hearing. But those things still need to be resolved and clarified.
So what is it then that you think? I'm sorry if I didn't follow you fully, that you could advocate at a next monitoring hearing that you couldn't do now? Is that because you're not as familiar with the document as you'd like to be, and therefore you're not in a position to comment, or is it something else? I'm just trying to follow you.
No, Your Honor, it's really a monitoring, it's in a monitoring capacity that I am inviting the court for us to keep at the next hearing, for us to supervise that this plan that has been set forth now in this letter is properly implemented. It won't have anything to do on the substance of this working draft, as Your Honor has indicated that perhaps is now, we are now at a stage where we want to keep the monitoring and the adjudicative function of this court very clearly delineated. But
Yes.
I think that at this point, all that we have is an engagement of the draftsperson and in principle, an understanding that there will be a review panel. But for the purpose of our proceedings, Your Honor, I think it would be useful if we could report to the court what really the parties have agreed to with respect to the function and mandate of the review panel.
I see.
So it's a purely supervisory role that I think would benefit the process.
Okay. Mr. Marshallek, do you see utility in that approach?
Your Honor, I understand why my friend might wish a little more formality, and we can seek to draft something that accommodates and provides some guidance to the review panel. I was hoping not to be in a position of being accused of trying to restrict what they can do in any way. But if we can agree it, I have no trouble putting some broad terms of reference together and a schedule to guide them. As for the last hearing, maybe a last hearing can be set for the anniversary of the consent order, and hopefully this can be presented and the work of the review panel pushed off. I don't expect very much on that occasion, except
Yes.
the terms of reference and the fact that the draft then, as opposed to a working document, is being presented for review.
Yes.
Yes.
Okay. All right. Could I invite you, if that is the sum total of the submissions, to just bear with us for a few minutes while we go offline to have a quick discussion, and we will be back. I'm very sure that Ms. Dookie will transport us to the other place so that we can have a private chat. Thank you.
Much obliged, Your Honors.
may we resume?
Yes, President. Seeing all the judges, and I'm seeing counsel for both sides.
Yes, thank you. I'm not seeing counsel for the, oh, here we are, the respondent.
Yes.
Thank you very much. Well, we have listened to your submissions and we have considered them carefully. And the eloquence of the submissions is such that we feel that we cannot deny you the opportunity for a final hearing. So especially since, you know, both sides are not always united on anything, but you seem to be united on this one. So we have agreed then that we will have the final monitoring hearing towards the end of October. Perhaps you could just confirm with us that the anniversary date is the 30th of October? It is? Okay, so we are proposing then to have a monitoring hearing on the 30th of October this year, 11 a.m. Trinidad time and 9 a.m. Belizean time. We further expect that there will be 3 deliverables that you will help us with on that date. Not necessarily in this order, but there will, of course, have been the draft bill completed by the draft person. So that is one thing we'd like to hear you on that date. Secondly, the terms of reference for the review committee will be clarified, clear. And I hope that's a very important aspect, of course. So I really hope that we can all agree on that. And then the schedule for what follows thereafter, after the review by the review committee, to the point where the legislation is in Parliament. Some of the dates there may be a bit speculative, we understand that, but we would like to have some idea as to how you see the process evolving to a completion. Is that satisfactory to both sides?
Much obliged, Your Honor.
Yes, Your Honor.
Thank you. Okay, well, thank you very much, Counsel, for your appearance today. Ms. Mendez asks through Mr. Hughes, I did not see your constituents as they are normally in court. May I ask if they're here at the present time?
Yes, Your Honor, some of them are here. We just had some technical issues with showing them, but they're beside me, surrounding me.
Wonderful.
Yes,
But we expect to see them on the 30th, if that is okay.
Yes, Your Honor, now that we have convinced the court to have one last one.
Yes, yes. We like to see you, of course, but we also would love to see your constituents accompanying you. Thank you so much.
Yes, they will
indeed.
be present. Thank you.
Thank you, ma'am. Thank you.
Much obliged, Your Honor.
Okay, thank you, Counsel.
Thank you.
Madam Deputy Registrar, would you mind closing the proceedings?
Certainly. Thank you, President Anderson. Thank you, Madam Justice Raj Nosley. Thank you, Madam Justice Unonu. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. The court now stands adjourned. Good day to all. Thank you.
Good day.
Yes.
Thank you very
Thank you.
much.
Bye-bye.